Welcome back to another edition of Between Two Fars. I'm Mordecai Miller, and I am joined once again by Judge Reid Prouty, Vice Chairman of the Armed Services Board of Contract Appeals. Today we're going to be talking about routine motion practice, scheduling orders, and other things that come up in every single case. But the decorum and the process are very, very important. And I'm very glad you're here today to give us some insight on how to keep the judge happy and not unnecessarily tick off your ASBCA judge. So could we just maybe talk about the types of routine motions that you would expect to see and the behavior you'd want to see from your counsel?
You bet. Thanks, Warnicky. This will be relatively short, but typically there's a scheduling order at some point in the proceedings that sort of says when things are due and when we're going to hearing and things of that nature. And shockingly, most of those scheduling orders need to be revised as time goes on. Discovery takes longer than expected, something occurs. It's very routine, happens all the time. So what happens when that happens is the parties make, usually one party makes, a motion for extension of time or to revise a scheduling order. Not a big deal, pretty routine, and we're happy to grant it. However, if it is one party making the motion, and that's usually the way you do it, I need you to tell me what the other party thinks of your motion. So usually that means you'll have talked to them and they agree to it. So tie your motion, consent motion to extend deadlines. And also in the body of the motion, don't only title it that, but say, I've discussed this with counsel for appellant, and he or she agrees to this or has no objection, whatever the case might be. Now, if there is an objection, well, say that too. You can say so-and-so opposes it. Because when I see the motion come across my desk, my virtual desk because it's done electronically, I'll say, okay, is it opposed? And if I don't know if it's opposed, I'm going to have to issue an order saying, all right, I've got this motion from the government or this motion from the appellant that is asking for this and doesn't represent if it's opposed. So, appellant, you've got a week to tell me whether or not you oppose this, and if you do oppose it, what your basis for the opposition is. And if they say, well, I don't oppose it at all, then you just wasted my time. And also, I didn't grant your motion immediately, which I would have otherwise been happy to do, and most judges would be happy to do. Now, again, every judge has his or her discretion, and they can deny these routine motions if they feel like it's letting the schedule get out of hand. But your typical motion for extension of time that is consented to is going to be routinely granted in the typical circumstances, as long as you're not asking for an inordinate amount of time. If you're asking for 2 years, that might be an issue. They're saying, look, we want to extend this by 2 months, something like that, and it's not on the eve of trial. You're very likely to have a routine response by the judge saying, fine, here's a change. Again, every routine thing has its reasons why it might not be routine, but for the most part, you'd be okay. Now, some people coming from private practice think, oh, I need to attach a blank order for the judge to sign.
That was going to be my question. Do you need draft orders?
No.
No. Okay.
And the reason for that is because the way we do it. Rather than in the old days, especially for people with big municipal dockets, it'd be pretty typical for a judge to sort of just rip that off the back of the order, sign it, and then give it to the clerk's office to file. That's not how we do our practice. The way we do our practice is we actually write the orders ourselves, and we have a template on our computers that helps us do that. So there's no saving of time on our part by you doing this in the first instance.
Okay.
So don't waste your time. It's not necessary. I will say, though, one good thing about those orders, the form order, that's what it is it actually says what you want. So if you want an extension of time, don't say, I want a reasonable extension of time, because I have no idea what that is. Give me a real life number so that when we issue the order, we can say it is extended by 30 days, 60 days, whatever. And even better, if the scheduling order that you're asking to amend has particular dates on it, don't just say extended by 30 days and force me to sort of whip out my calendar and tab through it and add 30 to all those things. Say 30 days, changing this number from this date to that date. Make life a whole lot simpler for me, and I'll be grateful. So that's routine orders, routine motions to change things, which brings up scheduling orders. And you're going to see scheduling orders in any litigation. And the only thing I ask you about that is when you have an order telling you to do something, comply with it. Or if you can't comply with it, ask for permission not to comply with it. Probably one of my pet peeves is when we say, okay, we're going to have a status conference and we're going to discuss X at that status conference. Now, if we're going to talk about scheduling at a status conference, I will be very disappointed in you if you and your opposing counsel haven't been on the phone a couple of days in advance to sort of set out what you're going to agree to as far as scheduling goes, or at least to find out where you guys depart. Where one party wants to have discovery done in 3 months, and the government wants to get it done in 3 years. Okay, it's an exaggeration, but not by much. You have to basically you have to try to have an agreement if you can have an agreement on a schedule when you go into the status conference with a judge, you'll make that judge very happy, because then she or he only has to say, well, that sounds very reasonable to me. I'm going to adopt your things, your dates. If you don't, what's going to happen? Are we going to set it right then and there? Well, usually there's hemming and hawing, and then often people say, well, let us talk. We'll get you a motion or a status report in a week telling you what it's going to be. Okay, I'm not going to scream at or take your head off, but I'm going to like you a whole lot more if we only have to deal with this once, and we do it right then and there at the status conference. So those are little things that you can do, and that'll make the judge like you better.
Excellent. We really appreciate the insight on this, and I think we need to tackle another subject. The best way to tick off a judge is a discovery dispute. So why don't we come back for another episode and dive right into how do we not tick off a judge if we've got a discovery dispute? Join us again next time, Between Two FARs.